You have 15 minutes, and you may reserve up to 5 minutes for rebuttal if you wish.
Thank you, Your Honor. Good morning, Your Honor.
And if you do want to reserve some time, let me know how much, and I'll give you a signal when to stop.
I appreciate it. I would like to reserve 3 minutes. I think that would be enough. May it please the court, my name is John Torella, and I represent Mr. Ronald Nelson in this appeal. Let me start by directing the court's attention to the trial court's most recent pronouncements in this case, the judgment entry of March 2, 2016. There you will find the underlying predicate of the lower court's analysis, and its eventual conclusion is set out at page 4 of that entry. The court concluded, adopting wife's interpretation of restored is consistent with the separation agreement's goal of equitably dividing the marital assets and liabilities. Your Honors, nowhere in the separation agreement or in the record in this matter is there any statement or reference by the parties that they had a goal to either equally or equitably divide their property. Yet, from this faulty premise, the trial court sought further support by referencing that the court must equitably divide the parties' marital property. That's the reference, if you will, to Revised Code Section 3105.171C1. However, this particular statement is simply an erroneous application of the law. If I may direct the court to pages 4 and 5 of my reply brief, the difference between dividing marital property as the consequence of an adjudication at trial or as the product of a negotiation between parties in the form of a settlement agreement or separation agreement is explained. I reference the case of Walther versus Walther, 102 Ohio Appellate 3rd, 378, a First District decision, 1995. In that case, Mr. and Mrs. Walther entered into an agreement settling their divorce and settling the terms of the division of their marital assets and liabilities. In so doing, they put that settlement on the record. As is typical, following up the settlement agreement on the record, a divorce decree had to be prepared. During that intervening time, Mrs. Walther decided, I think the agreement's unfair. I'm not going to sign the decree. Her attorney, she actually terminated her relationship with the first attorney, brought in a new one. They filed a motion with the trial court asking the court to find the terms and conditions of her separation agreement and settlement agreement to be unfair. The court conducted a hearing. The magistrate determined that he would confine the hearing to the question of whether or not Mrs. Walther was able to prove that the terms and conditions of the settlement agreement were the product of undue influence, duress, or coercion. The magistrate determined that that evidence was not presented. As a result, he found the separation agreement to be valid and enforceable. Mrs. Walther then filed her appeal. At page 382 of Walther, you will find that the Court of Appeals said, in a trial, the court is obligated to make a division based on principles of equitable distribution. That's the reference again to the Revised Code, 3105.171C1. It also is the public policy notion that you will note that my esteemed colleague has put in his brief on behalf of Mrs. Nelson. That's the public policy theory. However, if you go back to Walther, you will find at page 383, the court discusses the difference between dividing marital property by trial or by settlement agreement. The court court said, on the other hand, the contract does not have to be fair or equitable to be enforceable. Contracts, including settlement agreements, can be unfair or favor one side more than the other. So what are we dealing with here today? If you look at the divorce decree in this case, top of page 2, the trial court acknowledged that the property division in this case was the product of negotiation. Take that point back to Walther, where it said, neither a change of heart nor poor legal advice is a ground to set aside a settlement agreement. That notion, if you will, is by no means foreign to this particular court. Because in 1998, this very court, in George versus George, 1998 Ohio Appellate, Lexus at 4389, decided on September 23 of 98. In the George case, the parties entered into a settlement agreement placed on the record, the essence of which said that Mrs. George would receive 1/2 of the value of Mr. George's pension as of the date of divorce. Their date of divorce, November 22, 1994. When Mr. George's attorney prepared the qualified domestic relations order to provide for that division, that's all he provided. Mrs. George gets 1/2 of the value as of November 22, 1994. Mrs. George then said, I'm not going to sign that. That's not what is typically done in a domestic relations case. Normally you get some other things. So she filed a motion with the trial court. And there the magistrate said, yes, you're right. The domestic relations court, when it issues such an order, typically does include some other language. Such things as cost of living adjustments, pre-retirement death benefits, traditional coverture fractions, investment gains and losses. So the trial court said, we're going to change that domestic relations order, the QDRO, and we're going to include that language. Mr. George took the matter to this very Court of Appeals. And the court said, a party is not entitled to a modification simply because he or she made a bad bargain. A trial court may not rewrite a contract simply because it believes that the agreement could have been made more fair, except fraud, duress, or undue influence. You will notice in the Nelson case today, none of those claims have ever been made. These parties were represented by very experienced and well-respected domestic relations orders. I would ask the court to again refer to my reply brief at page 8, where I offer the court the case of Richmond versus Evans, 2015 Ohio Appellate, Ohio 870, an 8th District Court case dated March 12 of that year, 2015. In that case, the plaintiff wanted the parties entered into a separation agreement settling their property division. Later, much later, the plaintiff wanted the separation agreement set aside because she neither considered nor was advised of the significant tax ramifications as the consequence of part of that property division. And she said, I didn't think about that, and it's significant. This agreement needs to be set aside. Those terms are unfair. I point out in my reply brief that the ordering paragraph 34 of that case says, in this case, the parties, with the assistance of counsel, negotiated the terms of the settlement for 2 days, then prepared a detailed 9-page written settlement agreement. The fact that Mrs. Richmond may have misunderstood her obligations or experienced a change of heart based on further consideration of the tax ramifications of the property settlement does not negate the settlement she previously agreed to. Bad advice from counsel or haste are not meritorious defenses to the enforceability of a contract. That, Your Honor, is precisely what we have here today. Mr. and Mrs. Nelson, among other things, negotiated the terms and conditions of what to do with Mr. Nelson's U.S. Airways pilot pension plan. As we all know from the documents presented to you, U.S. Airways was in bankruptcy. Their pension plan was terminated as of March 31, 2003. It did not exist. When the parties came to court to present their settlement agreement on May 19 of 2003, they acknowledged in that agreement that the pilot pension plan was terminated. They then addressed specifically what was to happen if U.S. Airways came out of its bankruptcy and the pension plan was put back into effect, restored, if you will. The problem for Mrs. Nelson was that she only negotiated what would happen if the plan were to be brought back. What she failed to do was to negotiate what happens if the plan is never returned.
Was there any, in the plan itself, the pension plan, the documents for the defined benefit plan, was there anything in the language in the plan that said that if this plan goes away, PCBG can step in and it's insured?
Not that I'm aware of, no, Your Honor. The fact of the matter is, what the parties agreed to was that because U.S. Airways was in bankruptcy and the plan was actually terminated, it no longer existed. The parties then said, well, if it comes back, they anticipated the possibility that U.S. Airways could be restored out of bankruptcy. And if they did, they got their plan back, then Mrs. Nelson would share in whatever value was earned during the course of the marriage. But much the same as Mrs. Richmond, Mrs. Nelson overlooked the possibility of what do I do if the plan is never returned. And that's what happened to Mrs. Richmond when she said, I have agreed to these terms from the property division, and then one of those terms was that some property needed to be sold. She had to then suffer the consequences of the tax ramifications. And her argument was, well, wait, we didn't think about that. The Court of Appeals said, you're bound by your agreement. We're not permitted to step back in and try to fix it because you today think it's unfair.
And now you write your 3 minutes.
I will reserve my time and yield to my distinguished colleague. Thank you.
Morning again. Steve Bailey, sorry. Oh, she's not going to take it? Okay. Steve Bailey for Patricia Nelson. I actually find myself in agreement with almost everything my opposing counsel just said, in the sense that the case law is replete and without doubt stands for the proposition that bad deals and bad legal advice do not excuse someone from an agreement. Where we have our difference, of course, is that that is what this is, because it's not. The attorneys that handle this case at the trial court level are in fact experienced and respected trial lawyers, but they are not experts in ERISA, as none of us are, except those of you who've chosen to turn their life over to that volume of statutes. And so here's what happens in a defined benefit plan when the company goes bankrupt. In a defined benefit plan, when the company goes bankrupt, the administration of that pension is turned over to the PBGC. PBGC being a quasi-governmental agency that insures pension benefits. Now, a lot of bad things happen. They freeze the pension, so no matter how long you continue to work, you don't get any more money. They sometimes roll back the pension. If it's in bad enough economic shape, they roll it back. So it's not immediately apparent when the PBGC takes over a defined benefit pension how much the folks are going to get. So when they were negotiating this particular agreement, as the record shows, the pension had been eliminated. And by the way, that's the word used in the decree, eliminated, not terminated, eliminated. And
what's the effect of using that word as opposed to terminated?
well, because the argument, Your Honor, in the trial court by the other side was that this was all a very hyper-technical meaning. The word restored, particularly, was to be given a hyper-technical meaning as it applies in ERISA. And what I guess I'm pointing out here is ERISA also uses the word terminate, not eliminate. So the fact that they use the word eliminate is just one more reason to conclude that they were not referring to ERISA language when they did this agreement. So at that moment, the pension had been eliminated. But I presume, I don't know what the lawyers knew, but as a matter of fact, when that happens to a pension, we know that the benefits might be restored either in full or in part at some point in the future by the PBGC. And there's simply no way that there's nothing in the record, there's nothing in the rest of the agreement that would imply that Ms. Nelson ever had an intention of giving away her right to those benefits if they were restored. Now, that's where we come to the heart of the case, the word restored. Because the argument by Mr. Nelson at the trial court and his expert were restored has a very specific meaning in ERISA. That means that the plan is actually put back to where it was before. And it's not being administered by the PBGC, it's restored to U.S. Airlines. What we argued and what the court ultimately agreed to was, no, restored, no one in that room was a ERISA expert. No one in that agreement was a ERISA expert. There's no reason to conclude that Mrs. Nelson, or Mr. Nelson for that matter, was relying upon this hyper-technical definition of the word restored when they made this deal. And so consequently, the court used a dictionary definition of restored. And under a dictionary definition of restored that normal human beings would use, these benefits were restored. They had gone away, they had been eliminated, they were restored.
And does that mean that they are restored retroactively to include that time period before the plan was again in place?
Well, yes, Your Honor, in this sense, sure, because when the benefits are restored, they're still predicated upon the earning years of the participant. And of course, in the division of a defined benefit pension, we confine the alternate payee, the wife in this case, to a share of the coverture fraction, only that share that was earned during the marriage. So when the benefits were restored, they were restored because of his prior employment. In point of fact, his employment going forward didn't add to them at all. Okay, so they were all from before the divorce had happened.
Was the dollar amount that was, after PBGC came into this, the dollar amount that was determined to be Mr. Nelson's, was it the same dollar amount that it would have been had the plan continued? Or at the time, I mean, at the time
No.
of bankruptcy filing, was it a percentage of it?
I mean, at
At the time of bankruptcy filing?
no is the answer, because had the bankruptcy never occurred, then obviously he would have continued to accrue benefits.
Right.
Whether it was the same, if you froze it on the day of the bankruptcy and looked at it under what he would have gotten if he'd have quit that day versus what he got from PBGC, the record is not clear. I will tell you there's substantial benefits, and I don't think they could be much lower than he would have gotten. But I don't think the record actually addresses that, to be honest with you. In fact, I'm sure the record doesn't address that question.
What are we to do if we agree with the restoration issue, but disagree with the trial court's finding it
asking a question. I'm not sure, I think that I would treat that finding by the trial court as superfluous. I don't know that it matters whether there was an expressed goal of equality in the separation agreement. I think, Your Honor, it is more to the point of what I said in my brief, which is the public policy in the division of property is clearly in favor of equal division. If you don't divide property equally as a court, you have to actually make findings as to why you're not doing that. And so I guess what I was arguing was, if one is looking at the intent of the parties, it is reasonable to assume that they intended what is, in fact, the public policy requirement of the statute, rather than to leap to a conclusion that they intended it to be unequal. In point of fact, I mean, we do unequal separation agreements, we do them. But most of the time, you're going to find some justification in the separation agreement. Because the wife is waived spousal support, she's getting more of this. There's no indication in the separation agreement that there was any quid pro quo for her giving up this incredibly valuable benefit. This is her old age. This is her pension. This is her life beyond age 65. Surely, just as a matter of common sense, had they intended, the parties intended for that to be given up, there would have been some commentary on it. The only way you can reach the conclusion that Mr. Nelson urges you to reach is if you believe that Mrs. Nelson was actually acting upon the word restore as it's meant in ERISA. And I don't think that that is a reasonable assumption. And as this court has noted, when language admits itself of one or more meanings, that is the definition of an ambiguity. And it's the job of the court to fill in the ambiguity. The court did that. I don't think it abused its discretion in doing that. I don't think it lost its way in doing that. It found what I believe to be very well reasoned, that the parties did not intend this hyper-technical definition of the word restore than a normal English language definition of the word restore. And nothing further.
Okay, thank you.
Thank you.
And you have 3 minutes.
Thank you. Your Honor, first of all, let me get rid of this red herring about the word restored. The word restored has nothing to do with some hyper-technical ERISA definition. It was defined by the trial court. It means to put or bring back into existence something that existed previously. If you look at the circumstances, we're talking about the U.S. Airways pilot pension plan. Did that plan return in existence? No, absolutely not.
Isn't that the hyper-technical part of it, though? I mean, the money that the husband's going to get derived from the pension, whether it came from the U.S. Airways pilot pension defined benefit plan, or if it came from PCBG, he wouldn't have gotten the money but for there being a plan in the first place, right?
But the fact of the matter is that at the time of this divorce, 2003, there were no PBGC benefits. There were no insurance proceeds. There was nothing.
But
It
they
didn't
had
happen
declared
for 11
bankruptcy
years.
when?
I'm sorry?
But they declared, from what I read in your brief,
The bankruptcy was determined, the plan was eliminated by the U.S. Bankruptcy Court on March 31, 2003.
and the divorce was final on
May 19
June
of
3rd,
2003, and the decree was entered on June 5. That's correct.
So
Mrs. Nelson's complaint that I missed the idea of insurance benefits did not come back for almost 11 years because no one knew there were any such benefits for that entire decade. Bear in mind, litigation was going on involving U.S. Airways. There was also legislation going on involving U.S. Airways with the attempt to try to take them out of bankruptcy and restore their pension plan. So no one had any idea that there were any insurance benefits whatsoever. That didn't come about until US Airways was effectively gone. They were absorbed by American Airlines. At that stage, then, insurance benefits through the Pension Benefit Guarantee Corporation became possible. But bear in mind, they're not pension benefits. Those are the insurance funds of a government-sponsored program of pooled money. It's not from US Airways. It is not from his pension. This is a collective of money.
But you wouldn't say that it's his proportionate share of that pool of money came to him as a result of his serving as a pilot for US Air.
He was eligible for possible insurance benefits by virtue of the fact that there was at one time a pension plan that was funded through the ERISA program. But this idea that no one understood the definition of restored is irrelevant. There was no such technical definition. The only issue about restored was if a pension plan that is under a distress termination is restored, what would it look like? And the expert testified at trial, at hearing, that it would have an environment that is as follows. US Airways would be back, the pension plan would be back, and it would be operating under the original plan documents. That's what would happen if the plan were ever restored. The real point here is that the property was never divided by the court. This is not a statutory public policy case. This is a negotiation between two people. And the bottom line is that they negotiated everything but what to do in the event that US Airways never gets back into the marketplace. That's what happened. Just as with Mrs. Richmond in Richmond versus Evans and Mrs. George.
Then explain to me why in their the language of their separation, what significance then does the language where it says, if the pension defined benefit is restored and subject to any modifications made by the United States Bank of New York or by the Congress of the United States.
Okay, the reason
what does that have to do with anything then?
Because as I said to you earlier, at the time that this case was going on for divorce, and these parties were negotiating their separation agreement, there was litigation involving the Pilots Association on behalf of, against US Airways to try to get the pension put back into effect and get them out of bankruptcy. Because it was some possibility of that not being successful, there was also congressional legislation being proposed to try to take, again, US Airways out of its dilemma and let them have their pension plan back. That was ongoing. That's why that language is in there. Because no one knew at the time that if this pension is in fact restored, will it be restored completely, or will Congress have said something different? Or will the bankruptcy court have said something different? But the language was that the plan has to be back.
And you have about 15 seconds to conclude.
And Your Honor, I think I think that that's clear. I think if you go to the separation agreement itself, you will find at page 13 that all of the references are to the qualified domestic relation orders, not singular, plural, to the pension plans, not singular, plural, and that the QDROs are restricted to the court is restricted against revising or altering in any manner the provisions of those terms. Thank you.
We will take the case under advisement, send you a copy of our opinion when it's issued, and have a good day. Enjoy the sunshine.
Thank you, Your Honor.